Non-absente clause and the words without prejudice. A clause beginning with the words notwithstanding anything contained in this act or notwithstanding saying anything contained in a chapter or a section is sometimes appended at the beginning of a section with a view to give the enacting part of that section an overriding effect over the provisions of the act mentioned in the said clause. Courts have held that sometimes where the non-absentee clause is very wide, it becomes necessary to restrict its scope to certain limited provisions of the act with which it is in conflict, having regard to the contents of the enacting part of the sections which follows the clause. The words without prejudice have a different meaning. A provision enacted without prejudice to another provision has the effect of not affecting the operation of the other provision. For example, a proviso permitting rules to be made under delegated legislation generally contains two clauses. First clause refers to the general rule making power of the government for purpose of implementing the act, while the latter clause would say that without prejudice to the generality of the first clause, such rule-making power shall be deemed to include the power to make rules on specific matters enumerated in the second clause. Shall and may. Next. The word shall is used to raise the presumption of something which is mandatory or imperative, while the words may is used to connote something which is not mandatory but is only directory or enabling. There are, however, certain exceptional where the words shall may not mean something which is mandatory or where the may still connote something which is mandatory. However, if the same section uses the word shall at one place and may at another place, the former is normally construed as mandatory, latter is merely directory. Sometimes the word shall is construed as a directory, where the consequences or penalty of not conforming to the mandate are not specified. In such cases, the word shall is treated as used in directory sense. Where the words shall are used for performing an act within term limits and non-compliance of the mandate may cause hardship and the consequences or penalty is not specified, it is treated as directory and as meaning only a fixation of a reasonable period, or an end. The word or is normally disjunctive and words add word in normally conjunctive, but at times they are read vice versa to give effect to the manifest intention of the legislature as disclosed from the context. If the lateral reading of the words produces an unintelligible or absurd result, and may be read as or may be read as and, but in such case the reading of the word and as or produces a grammatical distortion and makes no sense of the portion following the word and the word and cannot be read as or. In section 21D1 of the Bombay Lottery and Price Competitive Control and Tax Act 1948, Supreme Court read or and as and to give effect to the legislative intention. But in other cases, the word owner or master, as in section 1 clause 2 of the UK Oil and Navigable Water Act 55, were construed by the House of Lords to mean owner and master. Commencement, operation and repeal and revival of statutes. Heading. Under section 5 of the General Clauses Act, it is stated that when a central act is not expressed to come into operation on a particular day, then it comes into effect on the day on which it receives the assent of the President. Unless the contrary is expressed, the central act or regulation shall be construed as having come into operation immediately on the expiry of the day preceding its commencement. It is also customary to state that the act will come into force on the date on which its commencement is notified in the Gazette. Some acts state that certain sections will come into force forthwith, while some other actions will come into force on the day on which notification in Gazette is made in respect of the coming into force of those sections. Sometimes the statute is made applicable forthwith to certain persons or classes of persons or territory or goods, and it states that the government could, by notification in Gazette, extend its operation to other persons, classes of persons or territories. Retrospective operation of declaratory statute. In Mithilesh Kumari versus Prem Bihari Khare, AIR 1989, the Supreme Court held that the Benami Transactions Act was declaratory in nature, and so Section 4 of the Act applies retrospectively on Benami transactions of the past as well. Substantive rights cannot be affected by new statute. In Garikapati versus Subbaya AIR 1957, it was held that the suit valued at 11,000 was decided by High Court, but no special leave to appeal to SC was allowed on the ground that the minimum value of the suit was increased to 25,000 for appeal to SC. However, it was contended that the minimum value at the time of filling of the suit was 10,000, and so the right to appeal was already vested. SC accepted the contention and held that it is a substantive right and no legislature can take away unless explicitly stated so by the Act. Retrospective operation of laws regarding procedure and evidence. In Sriram, the Durga Prasad versus Director of Enforcement, Supreme Court held that Section 113A, which allows the court to presume that the husband is guilty of abetting suicide by his wife, is retrospectively applicable because it is only a matter of evidence and does not affect any substantive right. In B. Prabhakar Rao versus State of AP versus AR 1986, it was held that the age of retirement was reduced from 58 to 55. The government, after realizing injustice had been caused, and reversed the order. However, ordinance restoring the previous age of retirement took time to promulgate, and the employees who retired before the reversal were passed were excluded from the benefit. SC held law relating to age of retirement was anyway invalid due to arbitrary classification, so the new law must be given retrospectively. Next is Definitions and General Clauses Act that we'll study, page number 32.